Good afternoon, everyone. We'll get started here. We're talking today about damages in dog bite claims. My name is Lindsay Rodenberg. I'm one of the lawyers at Strigberger Brown Armstrong. If you're not familiar with the firm, we practice in a wide range of insurance defense matters. We have offices in Kitchener, which is where I'm based, as well as London and Toronto. If you do have questions today, there's a Q&A box that you can put them in, and at the end we should have time to answer those. If you'd like a copy of the slides, please feel free to send me an email and I can send those over to you. And just a reminder that we are recording this and it will go up on our website in the next couple of days. So what are we going to talk about today? We'll look at the framework for assessing general damages in dog bite claims. Then we're going to take a look specifically at psychological injuries, followed by how do you assess damages when a dog attacks another dog or pet, and then finally some tips for when you're defending claims. So first of all, Okay, the framework for assessing general damages. This is the basics, not specific to dogs at all. If you practice in bodily injury at all, you'll be familiar with this. But the purpose of general damages is to compensate the plaintiff for pain and suffering. It's fact specific. There will be a number of factors that you look at. And when we look at dog bites specifically, the case law really emphasizes that other cases are not necessarily helpful in deciding on general damages for dog bite claims, and it is a very fact-specific exercise. The other thing we've seen come out, which is interesting, a recent decision a couple months ago, the Martin decision, where the court actually held that comparison of general damages awards to motor vehicle accident cases is not helpful in assessing dog claims. There's a separate regime for dog bite general damages, and the motor vehicle cases, shouldn't be looked at. And I will say the rationale that was given for that was that motor vehicle defendants have insurance and dog bite defendants don't. And as we know, that's not necessarily the case, but I think there's still something to that underlying rationale that they do kind of appear or happen in different contexts and should be assessed separately. The other thing that we've seen come out of the case law is there's kind of an accepted range as to what generals should be for a dog bite or attack. Right now, the upper limits of that appears to be kind of in the range of $35,000 to $47,000. We had the Martin case, which I just mentioned. It's a 2022 decision. It looked at previous cases and noted that outside of one outlier, and I'll come back to that case, the upper limits on generals are about $35,000. Similarly, the Swafford decision, which is a couple years old now, it also looked at cases and it applied some inflation to those numbers and kind of put the upper range at about $47,000. So we'll look at a couple of cases just to give you a sense of how that's applied in practice. The first, we've got a couple on the lower end of the range. The Chatterton decision, I think, is quite helpful if you want to get a sense or an overview of damages awards prior to 2010. It goes over a lot of the cases. But in that case, the plaintiff suffered some puncture wounds to her hip. She had ongoing nightmares and a fear of dogs. The award there was $8,500 for her general damages, and the court really focused on the fact that she had minimal physical injuries and a continued ability to carry on with her day-to-day life. If we look then at Ray and Flowers, this was where a large dog had jumped up on the plaintiff's back and also bit her in the buttock. She definitely had some kind of surface wounds and scratches. She did talk about back pain after the incident, but at the trial, she kind of conceded that she didn't know that it was definitely because of the dog incident. And then again, some ongoing fear of dogs. And so here we see the general's award is quite low, 2,500. And I think that reflects again the kind of surface nature of the wounds that she sustained. If we though look then on the higher end of the range, a couple of cases, so the Swafford decision, which I mentioned earlier, here the dog bit the plaintiff on the hand and it seems kind of clenched and held on for a period of time. The plaintiff suffered some wounds that required stitches immediately after the incident. There was a prolonged healing period where he couldn't use his hand. And then he went on to develop a lump that was removed surgically, but kind of recurred. So at the time of trial, he had had 3 surgeries and was left with ongoing pain and functional limitations in his hand. So there we see a general's award on the higher end, $40,000 in that case. And then the Martin decision that I mentioned earlier, the plaintiff suffered a tibial plateau fracture. She also had surgery. She was in a wheelchair for a number of months after that surgery, couldn't walk, she couldn't drive for close to a year. Again, some ongoing fear and anxiety around dogs. And so here we see she was awarded $35,000, which Martin had held was the upper limit for generals. So on these higher end cases, you can see they're being driven by more injuries that are obviously more significant from the outset. They require perhaps surgery or prolonged rehab and often have an ongoing pain or functional limitation associated with them. I did want to mention the Constantinou case. This is the outlier case that Martin mentioned. And as you can see on the screen, the general's award there was $100,000, which is much higher than anything else we've seen in the case law. It was a significant injury. The plaintiff had a torn rotator cuff. She was kind of bit twice by the dog and pulled her arm away. She had to have surgery, and this affected her ability to work. She had some fairly active hobbies that she was involved in that she could no longer do. And so there we see the general's award was $100,000. The thing I will say about that case is that the court seems to have looked at factors that we would normally consider in awarding general damages, but it didn't do any kind of review of the dog cases or comparison to those awards. So I think it is fair to say that that case is an outlier, but it's a good one to be aware of, because I'm sure we'll see counsel kind of bring that one up in the future in the hopes of maybe setting the awards higher. In terms of psychological injuries, again, just starting at the basics, we have the Supreme Court decision from a few years ago that confirmed plaintiff can recover for mental injuries that are reasonably foreseeable. They have to prove them on a balance of probabilities. And most importantly, perhaps, they don't have to have expert evidence or a diagnosis to substantiate the injury. As long as the court is satisfied on the evidence that's presented that there has been a mental injury, then they can award damages for that. So for dog bites, on the one end of the spectrum, we have, I think, types of mental injuries which are common in terms of common sense can link them to being reasonably foreseeable to arising from a dog bite. And often the evidence of just the plaintiff themselves is sufficient to prove the injury. You don't need here any kind of expert evidence. So things we see here, the experience of the plaintiff when they kind of were involved in the attack. Was it a large dog? Was it a smaller dog? How long did the attack go on, and how vicious was it? So the court will kind of look at the emotional experience of the plaintiff as they were involved in the incident. Again, ongoing fear of dogs. I think that's pretty It's easy to see the connection between being bit or attacked and maybe have some anxiety around dogs in the future. Other things, was the attacking dog vaccinated? I've seen a couple of cases where they note how the dog wasn't vaccinated, and that caused some additional worry to the plaintiff in the days following the incident. They have to maybe go through additional vaccinations. So that's been recognized. We also have a recognition of upset to the plaintiff if they also see their pet being attacked. So the Somerville case, the plaintiff and his pet Chihuahua were attacked by a pit bull. Unfortunately, the plaintiff witnessed the death of his pet in that attack, and the court recognized there that there would be some upset or distress associated with witnessing that. I do want to emphasize, though, that the award there is not for the emotional loss of the pet. It's for the distress caused by witnessing the attack. And then finally, the post-bite behavior of the owners can play a role. We have the Meloche decision where the defendants had allowed their dogs to roam free on their property. They attacked the plaintiff next door. And then in the days following the attack, the owners still allowed the dogs to roam free, which caused some additional anxiety to the plaintiff. So in terms of how that figures into quantum, it's not the driving factor. If you look at the cases we discussed earlier, most or all of them had plaintiffs who had an ongoing fear of dogs. The cases that end up on the low end of the range for generals are at the low end because of the actual injuries they suffered, and the high ones are on the high end of the range because they've suffered more severe injuries. So these types of psychological complaints, I think, will give a bit of a boost or an enhancement to the general damages that are awarded. But like I said, they're not the driving factor. And the other thing I wanted to note, they're generally not awarded as a separate amount. Normally, there's just one number given for general damages, and the factors above are kind of listed as a component that went into consideration. However, that's not to say that a plaintiff couldn't have a more serious psychological injury that is the driving force behind the award of general damages. Sometimes we see allegations that the plaintiff, has severe ongoing depression or a really severe phobia of dogs following the incident. Often that's tied to then an allegation that the plaintiff can no longer work if they have a job that might involve incidental contact with dogs. For example, I had a file once with a real estate agent who said he could no longer do showings of houses because it might there might be a dog in the home. The other thing is they often come with an alleged need for counseling. If you do have a plaintiff who says they're going to counseling because of the incident, be sure to get those records. I often find that dog bites or attacks can be a bit of a gateway into therapy for people, and they might talk about the dog bite for the first session or two, and then after that they seem to be focused on other issues. The last thing I wanted to mention is the plaintiff does have a duty to mitigate. So if the plaintiff is alleging that they've got these really severe psychological impacts from the incident that is affecting things like their ability to work, then they probably should be doing things like going to counseling. And if they're not kind of taking steps to address the issue, then that's a bit of a red flag, I think, in terms of the claim. With these kind of more severe types of injuries, I think the court is going to be more likely to want to have expert evidence or some sort of medical evidence to back up that there's something severe and ongoing here. And I've included the Moretto decision just to give you a sense of how the court has dealt with kind of these more common psychological complaints compared to more severe injuries. So this was a teenager. She was bit on the face. She reported nightmares and flashbacks of the incident. She had a fear of dogs, but she also said this was kind of more of a turning point in her life, that it severely affected her self-esteem. She stayed in an abusive relationship because of it, and there was some self-harm. And the court here accepted the kind of the complaints about fear of dogs and nightmares as having an impact on the plaintiff. But just based on the plaintiff's evidence as to the more severe psychological injuries, the court wasn't convinced. Part of that is because she had other pre-existing psychological injuries, but just based on what the plaintiff had presented, the court wasn't prepared to accept that there had been a more severe psychological injury. So here we see one case where they have split out the awards. So she had $40,000 for her physical injuries and then $5,000 for psychological. And that psychological, again, is the on the lower end, the fear of dogs, the nightmares. And so again, here we can see that the psychological component, if it's not a serious injury, it's not the driving force for the assessment of damages. So what happens when a dog attacks another dog or another pet, perhaps? Plaintiff can bring a claim forward for that. At this point, we're not then dealing with general damages. Dogs are considered property, and so the method of evaluating their damages is different. Courts do, though, there's a recognition that kind of dogs are a unique kind of property. They play a different role in our lives than, say, your refrigerator. And so I think there is some willingness to maybe blur the usual damages principles in terms of how they're applied to pets. But those are you start with property law principles as your starting point. And so if, for example, you think about, I don't know, maybe you have a flood in a house, you're going to send out a crew to do some emergency work, get the water out, secure the property. The equivalent to that for pets is kind of vet care done in the immediate aftermath of an attack. And I haven't seen any case law on that, but I think as long as the steps kind of taken or the costs incurred in the immediate aftermath were kind of done in good faith, then I think a court is going to be pretty willing to award those costs as kind of the equivalent of emergency work. Then you get into perhaps the dog has made it through the initial attack, but maybe they need surgery or rehab for the injuries they've suffered. From a property law starting point, we would probably say, well, it's cheaper to replace the dog with one of like kind and quality than it is to pay for a surgery, which can be quite expensive. I think this is one area where a court will be willing to kind of blur the lines a bit. If the surgery or rehab cost is not, too much higher than the replacement cost or is on the lower end, I think the court may be willing to award that cost, even if the replacement cost is technically cheaper. But I think as the differential between the replacement and repair grows larger, it's a harder argument for the plaintiff to make. I did have one file where it was an older dog and the plaintiffs were looking for about $20,000 for this dog to undergo surgery and then doggy rehab. And the pretrial judge had difficulties accepting that that was a reasonable position for them to take, in part due to the age of the dog, but also just the cost compared to what the dog was actually worth in terms of property concepts. Finally, the basis of the replacement cost. If sadly the pet dies, the plaintiff is entitled, I guess, to the the cost of replacing the dog with one of like kind and quality. They are not entitled to, say, the emotional replacement cost of the dog. So for many people, pets can, fill a big role in their lives. Someone's pet might be worth, to them 100,000, but they're not entitled to that amount just because the pet has an emotional value to them. The basis for replacement is what does it cost to replace the dog with a similar one. So lastly, just some considerations for if you're defending a claims. If you get word of the incident fairly soon after, any eyewitness statements, whether that be from your insured or other eyewitnesses, and video evidence, I think is quite helpful. Often we only have the plaintiff's description of what happened, and it's often in these types of incidents coming from a very emotional perspective for them. The severity and duration of the attack can sometimes appear quite extreme in the way they describe it. So I think if you have kind of more objective evidence that you can present in terms of how this happened, that can be helpful. There may be cases where it might just confirm how severe the attack was, but I think these are helpful things to have. Secondly, secure information about your insured dog. I think this is something that is sometimes overlooked because liability is often pretty straightforward under the Dog Owners Liability Act. But I think having photos of your dog, it can often help people to picture this dog in a non-violent context, which is helpful. And secondly, if you can get vet records that show this dog was up to date on its vaccinations and had been taken care of, I think that's just one avenue that you've kind of covered off in terms of the damages assessment. Lastly, if you're dealing with an injured dog, don't be afraid to kind of apply some of the practices you would do in a bodily injury case to an injured dog. So it might be appropriate to get the pre-incident vet records. In that case I mentioned where they wanted the expensive surgery for the dog, we got the dog's vet records, and it showed that this dog had had an x-ray sometime prior to the incident that showed there was spinal damage already. So now this dog has a pre-existing condition that might have resulted in the need for the surgery anyways. Secondly, surveillance of the dog. This is probably not something you're going to do often. However, I did have one case where the dog who was attacked was acting, or it had been trained as a medic alert type of dog. And the allegation was that this dog could no longer work after the attack, and it was going to cost tens of thousands of dollars to replace the dog with a similar one. I can't take credit for this, but before I got the file, the company sent out a surveillance team on the dog. The dog was on camera getting out of the car at school. It had its, medic alert vest on, and it went into the school with the child that it was, taking care of. So essentially, we got the dog working when we had been told that the dog was unable to work, and that kind of quashed that aspect of the claim. So again, probably not something you're going to do often, but something handy to maybe have in your back pocket. So with that, that's all I have for today. It looks like perhaps we might have one question, which I am having difficulty getting to with my mouse, but whoever you are, I will take a look at it and I can send you an email, or you can send me an email with your question. We do have these seminars about every 3 weeks, so we'll have a new one coming up in a couple weeks, and that topic will be announced soon. Oh, I might be able to get to the question here. Yes, OHIP subrogation for the plaintiff, yes. the plaintiff can and should be advancing any OHIP subrogated claim, and you're obligated to pay that as part of the claim. I think it's always worthwhile, like, pay attention to what OHIP has listed as part of their claim. I find they're not always accurate, and sometimes there are things in there that should not be in there. But yes, OHIP subrogated is part of the claim that can be recovered. So with that, I think we're just about done, but I want to thank you again for coming, and hopefully we'll see you on our next webinar.